Welcome to IP Concerns Deep Dive, the podcast version of our IP Concerns blog from Cascade Law Group. Here, we unpack intellectual property-related, real business and brand protection topics in a way that actually makes sense, no legal experience required.
Picture this. It's 3 o'clock in the morning. A figure in a dark hoodie steps up to the side of a forgotten, crumbling brick building in the middle of a city.
Right, a very familiar scene for this kind of thing.
Yeah, exactly. They pull out a piece of cut cardboard, hold it against the wall, and press the nozzle of a spray paint can. A few seconds of hissing paint and they just, vanish down an alleyway.
Leaving behind something that totally changes the landscape.
Yeah, because when the sun comes up, that neglected brick wall is suddenly worth $3 million. But here is the multi-million-dollar question. Who actually owns that newly created value?
That is the ultimate puzzle.
Right. I mean, is it the person who bought the bricks or the phantom who sprayed the paint? Welcome to today's deep dive.
Really glad to be here for this one. It's a fascinating topic.
It is. And if you are our resident learner, the kind of person who wants to thoroughly understand the hidden mechanics of the world without drowning in a textbook, well, you have found your spot. Today, we are pulling from a really brilliant piece of source material. It's an article titled The Banksy Paradox: Street Art, Identity, and Intellectual Property.
Which is such a great breakdown of the issue.
It really is. And our mission for this deep dive is to explore the incredibly chaotic intersection where rebellious, unauthorized street art crashes headfirst into the rigid, rule-bound world of intellectual property law.
And we get to use the world's most famous anonymous artist as our ultimate test case.
Exactly.
Oh.
Okay, let's unpack this. How on earth can public art, claimed by literally no one and often painted completely illegally, be privately owned?
Well, the contradiction is built right into the foundation of the act itself, and it begins like the very millisecond the paint hits the brick.
The millisecond it hits.
Yes. To understand this paradox, we have to look at the physical mechanics of how the law recognizes the creation of art. Under both United States and United Kingdom law, copyright protection isn't a form you fill out and mail to a government office.
Right. You don't have to register it right away.
Exactly. It is an automatic right. The protection attaches instantly the moment a creative work is, to use the legal phrasing, fixed in a tangible medium.
Fixed in a tangible medium.
Okay.
So as opposed to just an idea floating around in your head, it means the second the spray paint physically dries on that alleyway wall, the law recognizes it as a protected creation.
That is the threshold. In theory, under the absolute strictest reading of the law, Banksy's murals are fully protected by copyright the absolute second he steps away from the wall.
Wow. Even if it's just a quick stencil.
Yeah, the courts don't look at a stencil of a rat or, a riot police officer and judge its artistic merit to decide if it's original enough. The friction comes entirely from the context of the creation.
Because he didn't ask to paint it there.
Exactly. The art is brought into existence without the property owner's permission. So, legally speaking, the very act of creating the art constitutes vandalism. It is a literal crime.
Which feels like it should immediately short-circuit the whole system.
You would think so, right?
Yeah. I mean, if the physical act of making the art is a crime, the artist surely shouldn't be allowed to turn around and claim legal ownership of the evidence, right?
You would certainly think the illegality voids the copyright. However, courts historically have been incredibly reluctant to strip a creator of their intellectual property rights solely because the work was generated without authorization.
Wait, really? They still protect it?
They do. The rationale is that the intellectual property, the intangible creative expression itself, still inherently belongs to the artist who conceived it. But we hit a massive structural wall when we consider physical property rights.
The wall itself.
Literally. The physical canvas, the brick, the mortar, the side of the bakery belongs exclusively to the landowner. Therefore, the property owners hold the absolute unquestionable right to remove, paint over, or completely demolish the art.
I want to make sure you, listening as you commute or go about your day, are really visualizing this friction because it's so counterintuitive.
It's very strange to think about.
It's like writing a brilliantly original best-selling poem, but you wrote it in permanent marker on the hood of your neighbor's car. Who owns the masterpiece?
That analogy captures the dual nature of the problem perfectly. You retain the copyright to the sequence of words in that poem.
Right.
Your neighbor cannot legally copy those words into a book, publish it, and keep the profits. But your neighbor holds the title to that vehicle.
And they can wash their car.
Exactly. If they decide to drive through a car wash with a heavy-duty scrub brush and obliterate your poem, they aren't infringing on your copyright. They're simply exercising their right to clean their own property.
That is wild.
We are looking at a scenario where one individual holds the copyright to the invisible arrangement of the paint, while a completely different individual holds the deed to the physical surface holding the paint up.
And neither side can fully exercise their rights without running into the other. Plus, from Banksy's perspective, relying on copyright law is a tactical nightmare. If you actually want to sue someone for copyright infringement because they stole your design, you eventually have to walk into a courtroom.
Right, you can't stay a phantom forever in civil court.
Yeah, you have to stand in front of a judge and state on the public record, "Hi, I'm the person who painted this," which is essentially a confession to vandalism. He obviously won't do that.
If we connect this to the bigger picture, this specific tension forces artists who operate in the shadows to hunt for alternative legal armor.
They need a backup plan.
Exactly. When copyright becomes too dangerous to enforce because of the inherent illegality of the medium and, the strict requirement for a named plaintiff, the artist needs a legal backdoor. For Banksy, that alternative strategy was to aggressively utilize trademark law.
Which makes sense on the surface because his art wasn't just staying on the walls, it was being slapped on everything imaginable.
Right.
T-shirts, coffee mugs, posters, tote bags.
It was everywhere.
Entire companies were making millions of dollars mass-producing his work, and he wasn't seeing a dime. Now, based on his public persona, he didn't necessarily want the money.
Right, he's very anti-consumerist.
But he fundamentally didn't want corporate entities exploiting his anti-establishment art for profit either.
So the strategy he employed was highly unusual for a street artist. He began proactively registering trademarks for the images of his most iconic, recognizable works.
Oh, wow. Just trademarking the art directly.
Yes, but the goal was not to establish a traditional retail brand to monetize the art himself, but rather to use trademark law as a defensive shield. He wanted to legally block unauthorized commercial use by corporations and opportunistic bootleggers.
Okay, that sounds like a smart workaround.
It was clever, but however, this strategy eventually hit a fatal legal roadblock.
We are talking about the famous flower thrower case, right?
Yes, that's the one.
The image of the rioter with a bandana over his face, winding up to throw a bouquet of flowers instead of a Molotov cocktail.
In 2020, the European Union Intellectual Property Office, often referred to as the EUIPO, they issued a monumental ruling against Banksy specifically regarding that flower thrower artwork.
What did they do?
They reviewed his trademark application and completely invalidated it. They just stripped the protection away.
Here's where it gets really interesting, because I need to push back on the legal logic of that ruling for a second.
Okay, go for it.
Why does an artist actually need to provide a real legal name to hold a valid trademark? I mean, trademark is fundamentally about recognizing a brand and preventing confusion.
That is the general idea, yes.
Think about the golden arches of McDonald's or the Nike swoosh. When you see a stenciled rat holding a placard or that protester throwing the bouquet, you instantly globally recognize it as a Banksy.
You do. The brand is incredibly strong.
The brand identity is undeniably strong, regardless of what the artist's actual birth name is on his passport. Why isn't that enough for the Trademark Office?
It is a compelling argument from a cultural standpoint, but it fundamentally misinterprets the mechanical purpose of trademark law.
How so?
Well, a trademark is not designed to be a reward for achieving global fame or high recognizability. It is, at its core, a consumer protection mechanism.
Consumer protection.
Yes. The law requires consistent commercial use tied to a known, verified source. The entire point is so that consumers are not deceived into buying counterfeit goods. The law needs to know exactly who is responsible for the quality and origin of the product bearing that mark.
Ah, I see. It requires consistent commercial use, and Banksy's entire ethos is aggressively anti-commercial.
That is the exact contradiction the UIPO highlighted. The ruling noted that Banksy had made very public, very vocal statements denouncing the commercialization of art.
Oh, right.
He famously declared that copyright is for losers. The Trademark Office essentially ruled that you cannot publicly refuse to sell your art, mock the concept of intellectual property, and then turn around and attempt to use commercial trademark law solely as a tool to monopolize an image.
An image you have no intention of actually producing yourself.
Exactly.
So the Trademark Office basically called his bluff. They said he was filing in bad faith.
They did. When we analyze his fierce anti-establishment stance alongside his strict commitment to anonymity, it reveals a profound structural irony.
Which is?
The very characteristics that generated his massive cultural fame and his undeniable mystique are the exact things that make it nearly impossible for him to utilize traditional intellectual property tools.
That is such a fascinating catch-22.
It really is. The legal system simply cannot accommodate a ghost who refuses to play by the rules of commerce.
It's like he tried to patent a shadow. It looks like a solid shape until the legal system tries to grab hold of it, and then there's just nothing tangible to grip.
That's a great way to put it.
Which brings us to the inevitable pressure point. Because the legal system demands a real person, the effort to unmask Banksy isn't just a tabloid obsession anymore.
Right. The stakes have entirely shifted. Because intellectual property law fundamentally requires a known source to grant protection and assign liability, the pressure to finally unmask Banksy has evolved from a matter of cultural curiosity into a looming legal necessity.
For the longest time, guessing his identity was just a fun dinner party game. People would ask, is it a collective of different artists? Is it the lead singer of Massive Attack?
Right, and there's so many theories.
But the sources we are looking at point out that recent developments have aggressively narrowed this massive field of speculation down to one highly specific name: Robin Gunningham, a street artist originally based in Bristol.
The focus on Gunningham is intense, but what is truly fascinating is the methodology researchers use to point to him.
Yeah, let's talk about that.
We are not talking about simple hearsay or internet rumors. Academic researchers and investigative journalists have utilized advanced geographic mapping techniques.
Geographic mapping.
Yes. They essentially borrowed spatial profiling methodologies, the exact kind of analytical tools that criminologists use to track the anchor points of serial offenders.
Or like what epidemiologists use to trace a viral outbreak.
Exactly.
Let's pause on that because the mechanics of that are mind-blowing. They basically treated his art drops like a crime spree.
In a data sense, yes.
They overlaid a geographic map of the specific physical locations where Banksy's artworks mysteriously appeared over the years, and they cross-referenced that with a map of locations deeply tied to Robin Gunningham's personal life.
They plotted his hometown, specific addresses where he lived, local pubs he frequented, and playing fields he used.
And what did they find?
By running the spatial data, they found incredibly striking, statistically significant overlaps. The geographic nodes of Banksy's art perfectly shadowed the geographic nodes of Gunningham's life.
That creates a wildly compelling circumstantial case. But spatial mapping alone isn't a legal unmasking.
It isn't, but it represents the tightening net. Beyond the investigative journalism, there is tangible mounting pressure from the legal sector itself.
What kind of pressure?
We are currently seeing high-stakes legal disputes, potential defamation claims from companies he has criticized, and serious authentication issues surrounding high-value pieces of art.
The walls are closing in.
Yeah. The compounding weight of these legal maneuvers might very soon force a definitive, court-ordered unmasking.
Because eventually, a judge is going to demand a real legal name on a sworn document, or the case gets thrown out.
Exactly.
But let me pose this, and I want you listening to really consider the weight of this choice. If anonymity is the very engine that drives the mystique, the brand, and the cultural power of Banksy, does officially unmasking him save his legal rights, but completely destroy the magic of the art?
It's a huge risk.
Right. If Robin Gunningham has to stand up in court and say, "It's me," does the illusion just die?
What's fascinating here is that the legal architecture is entirely indifferent to magic or mystique.
The law doesn't care about the vibes.
Not at all. The court cares exclusively about liability, ownership, and origin. Let's systematically break down the specific intellectual property hurdles created by staying anonymous.
Okay, let's do it.
First, we have copyright. As we established, to enforce a copyright in civil court, you must eventually provide proof of authorship. You have to stand up and legally claim the act of creation.
Which means confessing to the graffiti.
Yes. Second, we have trademark. Trademark necessitates a known commercial source to protect the consumer.
Right, the UIPO ruling.
Exactly. And third, there is the concept of moral rights, which inherently require attribution to function. Choosing to remain anonymous is a powerful, deliberate artistic choice, but it is a choice that inherently and fundamentally weakens the creator's ability to enforce their rights in a court of law.
So let's play out the alternative. Let's say he chooses the mystique. He refuses to ever unmask, accepts that his intellectual property rights are essentially unenforceable, and lets the legal chips fall where they may.
Okay, assuming he just walks away from the legal fight.
What actually happens to the art itself? Does a Banksy mural, sitting out there on a public street, exposed to the elements, just magically under the public domain so anyone can use it?
From a strict legal standpoint, absolutely not. This is a very common misconception.
So it's not public property?
No. Even if street art exists in a shared, unprotected public space, and even if it is photographed millions of times a day and circulated freely across the global internet, the anonymous artist still legally holds the underlying copyright.
Okay, so the work does not default into the public domain simply because it is physically accessible.
Correct.
But practically speaking, if the artist refuses to ever show up in court to enforce that copyright, it functions exactly as if it were in the public domain. Anyone can print it on a t-shirt, and there's no legal goes who can stop them.
That is the practical reality. It creates an illusion of the public domain. The art is legally protected, but operationally defenseless.
Operationally defenseless. Wow.
And this specific tension doesn't just end with the economic right to sell t-shirts. It extends heavily into a separate legal category known as moral rights.
Let's define that, because copyright is usually what people think of. Copyright is the economic right to reproduce and sell the image. How do moral rights differ?
Moral rights are separate from economic rights. They are deeply personal to the creator.
Personal in what way?
They represent an artist's legal right to be properly credited for their work, and crucially, they include the right to object to the intentional distortion, mutilation, or physical destruction of their original creation.
Wait, let me make sure I have this straight. If a building owner decides they hate the mural on their wall and wants to bulldoze the entire building to build a parking lot, the artist's moral rights could theoretically legally stop the demolition.
In a theoretical sense, yes. In the United States, there is a very specific piece of legislation called the Visual Artists' Rights Act, commonly referred to as VAR.
Okay, VAR.
VAR was designed to offer limited legal protection against the destruction of significant art, even if the artist doesn't own the physical canvas.
That sounds like it should protect street art perfectly.
You would think so. However, when we apply VR to street art, we expose massive, glaring blind spots in the legislation.
Because it's a legal framework trying to govern graffiti, so of course the gears don't mesh. What are the blind spots?
The first major hurdle is that VAR typically only covers works that achieve a status of, quote, recognized stature.
Ah, so it has to be famous.
Right. And more importantly, it almost exclusively protects art that was created with the explicit permission of the property owner.
Oh, wow. So that completely leaves out the vast majority of everyday street artists.
It really does.
Think about the implications of that. If you are a brilliant local graffiti artist, but you don't have international fame, a judge can just decide your work isn't of recognized stature. And you certainly didn't have the landlord's permission to paint the wall. So VAR gives you zero legal recourse if the city council or the building owner just rolls over your work with a coat of cheap gray paint.
The legislation offers no shield whatsoever for the average street artist. Banksy is the extreme outlier in this scenario because his work undeniably possesses recognized stature globally.
But he still didn't have permission.
Right. The lack of initial permission still severely complicates any attempt to invoke moral rights. When you examine VRA closely, it is clearly a system designed by and for commissioned gallery artists. It completely fails to map onto the gritty, unauthorized realities of urban street art.
So what does this all mean? Let's bring this right back to your everyday life. Think about the next time you're walking down the street or maybe visiting a new neighborhood, and you stop to snap a photo of a brilliant, unauthorized mural painted on the side of an overpass.
It's an experience we all have.
You aren't just looking at public property, and you aren't just looking at vandalism. You are looking at a live, unresolved legal paradox hanging right there in front of you.
This raises an important question. How does our society truly balance the value of public, unfiltered accessibility against a creator's fundamental right to control their own work?
It's a tough balance.
It is. The core conflict we've distilled from all of these sources is a profound clash of foundations. Street art, by its very nature, thrives on accessibility. It is meant to be out in the open, it embraces impermanence, and it is designed to physically weather and interact with the harsh environment of the street.
But the entire foundational architecture of intellectual property law demands the exact opposite environment.
Precisely.
The law requires clear, undisputed ownership, permanent verifiable records, and absolute control over the asset.
The Banksy Paradox perfectly embodies this uneasy, chaotic coexistence. We are watching the ultimate anti-establishment artist attempt to bend the most rigid establishment rules to his will.
And it seems like it's not working.
The ultimate takeaway is that the legal architecture simply was not built to hold him. The line separating public expression from private property rights isn't just an abstract theoretical debate happening in a sterile courtroom.
It's happening right outside.
Exactly.
Okay.
It is physically being drawn and routinely painted over in the shared public spaces all around us, one unauthorized mural at a time.
That permanent marker on the neighbor's car hood we talked about at the beginning, it is not just a weird thought experiment. It is a legal crisis happening every single night in cities all over the globe.
It really is.
But before we wrap up this deep dive, I want to leave you with one final, slightly provocative thought to mull over on your own.
Oh, this is a good one.
We know from the sources that property owners will sometimes hire crews to physically chisel a Banksy mural right out of their brick wall so they can sell it.
It happens more often than you'd think.
Imagine that. If a property owner chips a multi-million-dollar Banksy mural off their building and sells it at a high-end auction, completely without the anonymous artist's consent, are they technically profiting off a crime that they themselves were the victim of?
That is the million-dollar question.
When the spray paint was an illegal act of vandalism, but the bricks belong to you, who really owns the soul and the value of that illegal act? Something to think about the next time you see writing on the wall.